Okay, I promise you that we'd be getting to patents, and today is the first day of our look at patents. I'm going to kind of give you a little overview so that you kind of appreciate, I think, where, the origins of patents, not because I think that you're history buffs or anything like that, but to understand how patent law today came about. It's useful to have at least a perspective on patent history. We've already gone over the fact that utility patents have a term of 20 years. Well, there's a reason for that. And, all of the other components of patent law have a history which provides, I think, some context and explanation for how we got where we are today. I've noticed that many of the questions that I get from you are, well, why is it 20 years? Or why are utility patents distinguishable from design patents? And I think understanding a little bit about the history of patents will sort of answer some of those questions for you. So I'll start by giving you a little overview of patents. First of all, what is a patent? A patent is a government license that gives the holder exclusive rights to a process, a design, or new invention for a designated period of time. And what's the designated period of time here on March 2nd, 2018 in the United States? What's the designated period of time? 20 years, exactly, except for design patents, which are 14. Exactly. And the purpose of the patent, like a copyright means right to copy. The purpose of a patent is to do one thing: exclude others from using your invention. Applications for patents are usually handled by a government agency. In this case, we've talked about it. The United States Patent and Trademark Office is the go-to place. Don't be afraid of their website. It's user-friendly. A lot of patents can be filed by the inventor. It's not a complicated process, depending upon what it is that you're seeking patent protection for. But I really suggest that just for the fun of it, you go on the website, go on the USPTO website, and kind of take a little look around. It's really a pretty well-designed website for inventors. It may save you some money being able to avoid a guy like me to do the busy work for you someday. The purpose of a patent, as we've discussed, is basically the same as other intellectual property rights. It's to give the inventor exclusive use over their creative work, and it provides an incentive for inventors and companies that do scientific research to control their creative works or their inventions so that they can have a return, so that they can monetize it. It provides them with an incentive to do research, to expand knowledge, to innovate. Patents are like any other form of intellectual property. They provide the monopoly that provides the incentive to monetize and get your return on investment. The purpose of a patent, for example, pharmaceutical companies. I mean, everybody's read about pharmaceutical patents, or at least the prices that pharmaceutical companies charge for drugs. They are partially reflective of the enormous development costs for certain pharmaceuticals. And there would be no incentive to innovate, to create these products, if it wasn't for the ability to monopolize and monetize that invention. Just a little overview of the sources of patent law, just so you know where it all comes from. Somebody asked me in the class the other day, well, where does the right to pass a copyright law come from? And we hadn't really gone over this, but it all goes back to the United States Constitution. Article 1, Section 8 of the United States Constitution is what grants the Congress the right to pass laws that protect intellectual property. And we'll go into it in a second, but this is really a brilliant document, the United States Constitution. The framers were really social architects. And back in the 1700s, when they met in Philadelphia to create this document, you got to understand a lot of the people that wrote that document were themselves inventors. In fact, some of them prolific inventors. All of them were moneyed, successful, and oftentimes that success really came from inventions that they had themselves created and controlled and monetized. So when they were drafting the United States Constitution and they were acting as social architects for a society, one of the things that they paid special attention to was the need to not only protect patents, but to promote the useful sciences. That was actually written into the founding document for this country. And then as time went on, Congress passed a Patent Act in 1790 and another one in 1793, then one in 1836. The Sherman Antitrust Act was sort of an anti-patent act because these original patent acts, it was viewed at the time, gave companies monopolistic control, which was bad for commerce, bad for competition. So Congress basically passed the Sherman Antitrust Act as kind of a counterbalance to the patent laws that they had previously passed. And then the Patent Act of 1952 is basically what we're operating from today. Most of patent law hasn't changed since 1952, except for the Leahy-Smith America Invents Act, which I've mentioned before, which was passed in 2011, which brought the United States into the 21st century and for the first time made us a first-to-file country. This Smith-Leahy Act changed the landscape of patent law in the United States more than almost anything else, because that's when it became imperative to be the first to file. Up until then, the way patents were kept secret or information was shared, or the way people approached protecting their intellectual property was completely different. Now, it's really been simplified with the Leahy-Smith Act. When in doubt, file your preliminary patent application, because that's the way to establish your right to the patent technology. So the Patent and Copyright Clause of the United States Constitution was proposed in 1787 by James Madison, who wrote in the Federalist Papers, and this shows you who these people were. The utility of the clause will scarcely be questioned. The copyright of authors has been solemnly adjudged in Great Britain to be a right of common law. The right to useful inventions seems with equal reason to belong to the inventors. The public good fully coincides in both cases with the claims of the individuals. You got to remember, these guys all came from Great Britain, and we talked about the Statute of Anne, and we talked about the recognition of copyrights and patents in Great Britain. So this is the tradition that they came from, and when creating a society here in the United States, especially guys like Madison and Franklin and Jefferson, all of whom were prolific inventors, they were really concerned with this aspect of intellectual property protection. Here's an actual picture of the Constitution, Article 1, Section 8, known as the Patent and Copyright Clause of the United States Constitution, is the foundation on which all of our intellectual property is based. And here it is. I thought you might want to actually take a look at it. Article 1, Section 8, the Congress shall have the power to provide for the general welfare of the United States, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. There it is. So that's the source of all intellectual property law. When you go into court and you're trying to enforce a copyright or a patent or a trademark, or you're being accused of infringement, this is the first step, and this is where the law comes from. I've already gone through this, and by the way, for those who are interested in it, I'll post the very detailed slide presentation. You know, I go through all of the history of patents. You know, here we're talking about Benjamin Franklin. He invented the bifocals. He was, a prolific inventor, but he was one of the original open sourcers too. He was tremendously concerned about the spread of knowledge. And so, in fact, he was one of the ones that argued in the constitutional conventions that preceded the adoption of the Constitution that the term of patents should be very short, because he was concerned that people would monopolize knowledge, and that would be bad for society. Thomas Jefferson, a prolific inventor, the swivel chair. Has anybody ever been to Monticello? Have gone down there and actually taken a look? This guy, was like a one-man patent office. If you go in there, there are examples of things that he has created that's really staggering, and it's no surprise that when we became a nation, we were sort of already up and running when it came to an advanced and fully developed system of patent laws. Many countries, like Great Britain, took centuries to develop intellectual property laws. As soon as the Constitution was adopted in 1787, we already had a fully developed foundation for intellectual property protections. Historically, this, as far as Great Britain goes, it goes back to the Statute of Monopolies in 1624. But there's evidence of patent and intellectual property protection in ancient Greece. The Venetians were prolific engineers and inventors. They had laws governing intellectual property. The term letters patent literally comes from Great Britain. And they literally provided the recipient with a monopoly on a particular invention. Of course, back then, it was not who was first to file, it's who knew the king. And one of the reasons why ultimately Parliament would get involved in developing statutes governing the law of intellectual property is because one of the reasons why the monarchy in Great Britain was so wealthy was because they would hand out these patents to their favored supporters and reap enormous amounts of money from it. The abuse by the kings and the queens of Britain was actually the genesis of all of our modern patent laws because of the abuse that occurred back then. The first Italian patent was awarded in Florence in 1421. This was the earliest picture I could come up with of an early patent, but there may be others that you can find. Yeah.
Isn't that Constitution? I'm really intrigued by that.
Yeah.
Constitution. Doesn't that do copyright as well?
Yes, it covers all forms of intellectual property, exactly. That is the basis for all of our intellectual property laws. That's what gave Congress the authority to act and create the statutes that they ultimately created, whether it happens to be the Patent Act of 1952 or the 2011 statute, or the Copyright Act, or the Trademark Act. All of those parts of the United States Code passed by the United States Congress were done because Congress was granted that power by the United States Constitution. No Article 1, Section 8, no patent laws, because the authority does not exist. If it's not, the thing about this country, if it ain't written down in the Constitution, they can't do it. Okay, so the powers of the presidency, the powers of the courts, the powers of Congress to legislate, all contained in the United States Constitution, and if it isn't in there, they can't do it. In fact, we'll go into it at some point, but there was a controversy about whether Congress actually had authority to write laws governing trademarks under this particular clause. And as the Supreme Court would ultimately find in a case which is detailed in the notes that I'll post, they found that it wasn't found in this clause, but it was found in another clause within the United States Constitution. But without the authority in the Constitution, it doesn't happen. All right. Enough of the history of patent law. Like I said, if you want to take a look at it, I'll post everything. This was this was actually the oldest patent I could find, notwithstanding the cavemen. This is the Venetian patent statute of 1474, and it's just an example of one of the earliest patents that historically to exist. Like I said, lots of history in the notes, but rather than go through those, what I'll do is post them. One kind of interesting note is a fellow by the name of Samuel Winslow was granted the first patent in North America by the Massachusetts General Court. The same building up on Beacon Hill where the legislature meets today, which our legislature is actually called the General Court. Back in 1641, before the United States existed, and this was Massachusetts Bay Colony, Samuel Winslow was granted the first patent by the Massachusetts General Court for a process of making salt. The first patent act of the United States, as I showed you on the interview, in the overview, was passed in 1790. And think about it. The first Congress acted within 3 years of the adoption of the United States Constitution. The United States Constitution ratified in 1787. Within 3 years, Congress is already up to speed in writing a patent law that shows how important it was back in those days, as it is today, for intellectual property rights to be protected. First patent in the United States under the patent law was granted to Samuel Hopkins for a process for producing potassium carbonate. And this is that's the actual patent. Without going into all the details of the Patent Act of 1790 and 1793 and subsequently, what you'd learn by going through that is that the law evolved slowly. In 1790, the term of a patent was only 14 years. Under the 1793 statute, the term of a patent was increased to 20 years. Under the 1793 statute, also, for the first time, they created a central office that governed patents and administered patents, which later would become the U.S. Patent and Trademark Office. It originally was handled by the Secretary of State. And the first evidence of patent infringement, of course, followed shortly after the first patent. There was a company called Bolton and Watt, which was headquartered either in New York or Massachusetts, I can't remember which. But what they used to do is they used to go all over the country suing people to invalidate their patents because they said that it infringed on their patent for boiler technology. Oftentimes, like today, because they were so powerful, the small inventors that they would take on would simply give in and turn over their patent technology to Bolton and Watt. One of the things that is true about patent law today is that might makes right. There are actual Supreme Court cases I can show you where the court says might does not make right. But I can tell you, as somebody that goes out there and tries these cases and argues in front of those courts, it's really true that might makes right more often than not. Big companies have always been taking advantage of little inventors. And one of the reasons why I thought this course was important is to sort of give you folks some insight into how inventors have been taken advantage of. Let me tell you, nobody's made any money ever working for somebody else. And big companies know this, like Bolton and Watt or Nike or Microsoft or Apple. They all know this. And it's important to know this stuff in order to protect yourself against the Bolton and Watts of the world. This is what happens oftentimes to innovators who come up with a good idea, but somebody bigger, stronger, faster, and better funded comes along and oftentimes can't defend themselves. In the very early days, the Patent Office used to require inventors to actually submit an example of their device. So if you go into the USPTO's museum, you can actually, it's like a warehouse, what do you call it, an airplane hangar. But the first 100,000 devices that were patented in this country, they had to, under the laws that existed at that time, actually submit the invention to the Patent Office. And it's put up on a shelf in the U.S. Patent Office even today. You can go in there. This is one of the earliest patents, 1718. It was a patent that was granted in either New York or Massachusetts, but of course it's a patent of a weapon of mass destruction. I thought that that was sort of interesting. There's, like I said, a lot more information in the presentation about the history of patent law. So with that sort of historical backdrop, what rights do patent owners have? Okay, a patent owner has the right to decide who may or who may not use the patented invention for a period of time that the patent exists. And patent owners give permission or licenses to other parties to use their inventions on mutually agreed terms. And owners of patents may also sell their invention rights to someone else who then becomes the new owner. So you can either license it, or you can take your better mousetrap and sell it to somebody else. That's oftentimes what happens with small inventors. Microsoft didn't get the size they are today by thinking up all of the things that they have patented. What they do is they come along and engulf and devour inventors who have ideas that are compatible with their business model. So a lot of companies grow by research and development, but most companies grow by coming along, finding a startup. I'm sorry, Simone is not here anymore. I'll predict for you though that somebody is going to come along and make Simone an offer one day because they want to acquire his startup for their company, and the time will come when he will be asked to either sell or license his technology to a company like Exxon or Mobil or whoever it happens to be. That's the way most companies grow. They don't grow necessarily by thinking up things themselves, although a lot of great research and development is done by corporations. They grow by acquiring people like you who create a startup, and then somebody comes along and writes you a check.
Is this a good time to ask what a patent pool is?
I'm going to get to it,
Okay.
all right? But yeah, it's related to it. A patent pool is basically a group that owns certain patent technology, and it's like a private agreement by which they all agree to share in it. And it's a way of first of all, affording the technology that's required to create the invention, and it's a way of sharing, sharing the burden and sharing the income from it. So oftentimes, well, I'll give you an example. Let's say you have 3 startups. They're all in the oil and gas pipeline, non-destructive, investigation business. But there's all kinds of different applications for that technology. And you don't have the resources to develop an investigative device for each application. But there are other people in the business that do, and they're far enough along. You've met them at some sort of, professional symposium. Well, you call them up on the phone and you say, hey, look, I was thinking of, it's essentially a joint venture. That's what a patent pool is. So you go into business, the entities remain separate, okay? But they all engage in a joint venture whereby they share certain patent technologies. And that way, they all share the risk and the cost, but they all share the benefits. And so what may be beyond the ability of one company to afford becomes doable. And in many ways, it's kind of an antitrust sort of device. It's a way of small companies competing with big companies because you get together and share in a joint venture. It makes it easier for you to be competitive with larger, more better funded corporations. Lifespan of a patent, we've covered this. If you don't know this, you haven't been eating my donuts on Friday. All right, so how does society benefit? I think we've sort of covered this, knowledge gets advanced. And inventors are incentivized to innovate and create more knowledge. All right, so what kind of patents are there? There are 3 kinds of patents: utility patents, design patents, and plant patents. Can anybody give me an example of a utility patent? Sure you can. Sure you can. Come on, if you try, you can. How about a mousetrap? All right, a mousetrap is an example of a utility patent, something that performs a useful function. In this case, catching mice. So a mousetrap is an example of a utility patent. Now, I know you can give me an example of a design patent. I wish I brought my 2 bottles in here again. I don't know why I don't carry those around with me all the time, but can anybody think of a design patent? An example of a design patent? Somebody who hasn't said something in class in a little while. Come on, I won't kill you. All right, the Coke bottle is a perfect example. That's what you were thinking of, I know. And a plant patent. Does anybody know what a plant patent is? Do any of you in biology here have a biology background? No? Anybody eat corn, soybeans, carrots, potatoes? Well, all of those come from usually, I don't know for sure, but I'm sure most of the plants I just named were at some point the product of a plant patent. Companies like Monsanto, which you may have heard of, spend an awful lot of money in research and development coming up with species that are disease resistant, create a greater yield per acre, and that takes a tremendous amount of investment. And in order to recoup that investment, Congress recognizes a plant patent, which applies to new species that are developed biologically. In genetic research, we're even creating new animal species, and those are subject to patents. When we get to that, of course, technology moves a lot faster than the law does, but we're getting into new technologies now where we're talking about new species of, not only new species of plants and animals, but we're talking about entirely new genus. So all of those are subject to intellectual property protection. Utility patents, 20 years. Design patents, 14 years. And plant patents, 20 years. Utility patents apply to new and useful processes, machines, manufacturers, compositions. Usually 3 types: mechanical, electrical, and chemical. The differences are beginning to become a little bit blurred as technology outpaces these categories. But generally, if you submit an application to the USPTO, they'll put it into one of those categories. Yes, sir.
Okay, so if the patent is good for 20 years, during the time of the patent, do you still pay for any years?
Pay for it?
Yeah.
No, it's not like a trademark that you have to renew every 5 years. A patent, once your patent is granted, it's yours. Well, it depends on what type of patent that you're looking for, but the cost is not in the filing. The cost is in the development of the application, oftentimes. A patent for a new mousetrap, not very expensive. You could probably do it in an hour, okay? But when you're talking about patenting a new species of soybean, or you're talking about patenting, a device that is used to shield people from X-rays, the technical drawings and things like that, and the research and development that goes into it is very expensive. But the applications themselves are a few $100s. So, and as I said, just take 5 minutes and go on the USPTO website and sort of look around. One of the things that you'll find there is that they have the patent office won't tell you when your patent expires, but they have a patent calculator. So you put in the date that your application was filed, and it'll tell you when your patent, how long your patent is good for. It also has a very important library where you can study the state of the art. We'll get into the requirements of a patentable device in a minute, but one of the things that you have to do in filing a patent is you have to go and look at what other people have filed. If you're going to file a patent for a mousetrap, you've got to look at the other patents on mousetraps that have been issued to make sure that your device has sufficient novelty and originality and non-obviousness to qualify for a patent. So it better be a better mousetrap, in other words. Although the differences between one patent and another can be very small. One example I use is there's a patent for a ceiling fan that was issued. Somebody else came along with a ceiling fan that looked exactly the same, but they painted it neon green so it glowed in the dark. Well, the U.S. Patent Office considered that sufficient novelty to issue a separate patent for it. Imagine how the guy that came up with the first, ceiling fan felt. So sometimes the requirements in order to distinguish your device from another is very small. But one of the things you have to do in filing a patent application is you have to go on the USPTO website and examine the other patents, which is called the state of the art, to make sure that your device has sufficient novelty under the statute, satisfies the statutory requirements, novelty and usefulness and non-obviousness. Those are the requirements, so that you can, in good faith, file the application. Because that's what the patent examiner will do. He'll look at the other mousetraps and say, this is just another mousetrap, and will reject your application. Okay? But go on the website and take a look. Just kind of root around in there. It's fascinating. That's where I got the pictures of all the crazy patents. Design patents apply to new and original ornamental designs like Coke bottles. I came up with a different example than a Coke bottle. You know, anybody has seen Oakley sunglasses. This is an example of a design patent that you come in contact with every day. This is the actual patent from the USPTO website for, I don't know if these are Oakley's, but, you know, what they find, you know, you say, well, these are just sunglasses, but the owner of that patent would say to you, oh, no, no, look at these little vents, and look at how these are curved, and look at the ergonomics of the nose piece. That's why I'm entitled to patent these things. And all of the specifications, the description and the things that are important about this patent are all contained in the on the slide. Things that make it distinguishable. Plant patents, I've already talked about those, but you know, basically plant patents cover almost any agricultural product. Here's an example of a plant patent. This is literally comes from the USPTO website. So what are the requirements for patent protection? Okay, so in order to obtain patent protection, you have to comply with those statutes that I was talking about that Congress passed. The most recent one, I told you, the 1952 Patent Act. Okay, so certain things are not patentable, if you will, and we've sort of already covered this. Things like scientific theories, mathematical formulas, plant and animal varieties, discoveries of natural substances, commercial methods, methods of medical treatments are usually not patentable. Although we've talked about overlapping intellectual property protection, some of those things could be protected by other forms of intellectual property protection. Another question from the Sloan School.
Yeah. Well, so this one says scientific theory and may not be patented. So what about computer code?
Computer code is different, okay? And computer code, sometimes it depends on, you know, how it is, well, you know the old answer. In law, it depends, okay? But with computer code, that's usually something that's covered by copyright. So software, things like that, would be covered by copyright. But I'm talking about the Pythagorean theorem, the laws of thermodynamics. Those are things that are in the what? They're in the public domain. You know, they're generally known. So you can't go to the U.S. Patent and Trademark Office and say, hey, I've got this great idea, E equals MC squared, okay? But if you come up with a way of applying that mathematical formula, that might be something that could be covered by a patent or by a copyright.
So what's the distinction? How do you distinguish when it says no plant or animal varieties, but then there's the plant patent, so it has to be a derivative?
Yes, exactly. So I can't go out and patent the blueberry bush. But if I take a blueberry bush and cross it with an apple tree, or let's say, let's say, how about crossing it with a jackrabbit? Okay, that is something that you might be able to, you know, patent. Okay, but an oak tree, no. An elm, no. But if you know, come up with a new variety, that would be covered by a plant
If
patent.
you discovered a plant that crossed a blueberry and apple or whatever, that wouldn't be patentable because it was a discovery, not necessarily a...
Exactly. Exactly. Unless, of course, somebody cultivated it and then you came upon it, in which case you may be just infringing on a patent, you know? Section 101 of the U.S. Patent Act sets out the general requirements of a utility patent. Whoever invents or discovers any new and useful process, okay, those are key words, machine, manufacture, or composition of matter, or any new and useful improvement thereon, may obtain a patent subject to the conditions and requirements of this title. Yes, sir.
Going back to the plant patent.
Yes.
Does the patenting company or individual, they have to provide any details of how they got their new plant or species?
Yes, they do. And that's part of the art of writing a patent application, because you as the inventor want to write enough about how you did it in order to obtain the patent protection, but you might not want to write so much that somebody can exploit your unique methodology. So there's an art and a science to writing a patent application. That's oftentimes where lawyers, I guess that's how those guys get to drive Lamborghinis that say, you know, IP law on them, because they're really adept. I don't know how to, I don't specialize in that, but and that's why I don't drive a Lamborghini, I guess. But they're very adept at coming up with a description that says just enough, but not so much that, you know, the cat is out of the bag. And as an inventor, it behooves you to, you know, follow that rule, because you don't want everybody coming in and dive bombing your, you know, your creative insights.
So, first to file only applies to patents.
Yes.
Not trademark.
Nope.
I guess only.
Well, yes, first to file only applies to patents. That's the rule. With trademarks, first to use in commerce, okay, is the rule and always has been the rule, okay? So if you use it first in commerce and have continuously used it in commerce, it qualifies, you own the trademark. And as far as copyrights are concerned, whoever, you know, writes it down first, okay? So in many ways, it's whoever comes up with the tangible expression of the idea is the owner of the intellectual property. In many ways, it wasn't until 2011 that patent law, you know, we were out of step with copyright and trademark until 2011. And now they're all uniform. It's whoever's first. Okay. These are the key words from the statute. So to be statutory, it has to be new, useful, and non-obvious. That's what the statute says. Those are the guidelines. If your invention qualifies, if your invention satisfies those requirements, it qualifies for patent protection. So, what is and what is not patentable? Oh, yes, I'm sorry.
So just to follow up on this question, can you ask me the difference between trademarks and patents?
Yes.
So assuming I am able to get a patent, but then I'm granting the permission to use my invention, is he able to get a trademark if he's the first to use that invention?
No, I think you're kind of conflating trademark and patents, okay? A trademark is like the MIT, okay? A name, a symbol, a logo. Although I understand, you know, how these things can be conflated, because as we talked, there are overlapping protections for these things. So if you were, let's go back to my mousetrap example. If you were the first to file the application for the preliminary patent application for the better mousetrap, then you would be the owner of the patent to that device. Now, you may at the same time want to trademark that, you know, as the better mousetrap. You know, maybe that's your logo, okay? And so you could trademark that at the same time and own and protect it that way. And at the same time, if you were kind of creative with this, I would draw a little mouse up there, a little dead mouse or something, but that could also be your logo. And so you'd be entitled to a design patent, okay? Remember the Coke bottles. I don't know if you were here for the Coke bottles, but you know, in a Coke bottle, there's a dozen different intellectual property protections. You have trademarks, you have design patents, you have patents on the sweeteners that are contained in the delicious contents of a Coke bottle. So, you know, there's all kinds of overlapping and concurrent types of intellectual property protection for any one particular invention. Like you say, you know, if you build a mousetrap, you can own the the utility patent on it, but you got to call it something, right? So then that might be, you know, a trademark. Does that answer your question? Okay. So what is and what is not patentable? Can you patent an idea? And this is the first time I've ever seen all the heads nod no. We're definitely making progress in this class because you couldn't even stop yourselves. You all shook your heads no. Correct. Books, literature, music? Probably not. But what does it? What do those things qualify for? Copyright, exactly. Natural laws? That's a big no. E equal MC squared? That's another big no. Electromagnetism? Exactly. No. Radio waves? No. Those are scientific phenomena. Okay, can I patent the rain out there? Can I patent a sunny day or a beautiful sunset? No. I have to make it. You have to be the inventor. It has to be new. It has to be useful. It has to be innovative. And it also has to be non-obvious. All right. A couple of really important patents that you might want to remember. This is a device that was an actual patent. This comes from the USPTO website. This is why I say go looking around on it. This is one of the figures from the patent of a hiccup treatment machine. Here's a high five machine, which is an actual patent. I'm sure all of you probably have one of these. Dog ear protectors. Actual patents. This I didn't think needed a title. I invite you all to fill in the blank. An actual patent from the U.S. Patent and Trademark Office. Okay, it's about time to quit. We're going to go through a couple of the other statutory requirements when we come back next week, and I'm going to get into actually patenting a thing. I'm going to bring in a prototype from Professor Alex Slocum, a friend of mine here, and we're going to show you how to actually patent something next time we meet. And I don't think that's until next Friday because Brian is going to be taking my class over on Tuesday, but I'm coming because I'm really interested in what he has to say, so I'll probably not see you until next Friday. But then we'll go into the rest of this, and by the time you walk out of here next week, you will know at least the beginnings on how to patent your own stuff. Thank you very much.